welcome to Legally Speaking with me, Tarun Nangia. Today we are going to discuss the twin condition for bail in the Prevention of Money Laundering Act. As we all know, businessmen across the country are running scared because there is a skepticism that even if they get bail or even if they are acquitted in the predicate offense, which is the first offense registered, following which the PMLA case has been made out, the PMLA case may still go on. But more than that, there is a fear among the business community that if there is a PMLA case, unfortunately, that they will face, they may have to spend years before they even get out of jail, in which not only the health of their company, but the health of the employees and their families, and also the company's loans may turn NPA. There are so many fallout effects, which we don't go into because we only see that the businessman has been put into jail, but there are larger issues to be discussed here. I have a very eminent panel who's now, in a sense, arguing before the Supreme Court India in a batch of matters that are being argued before the Supreme Court. May I introduce you, Senior Advocate Vikram Chaudhary. I don't need to introduce him. He's a well-known name on the subject. Thank you so much, and happy to see you again. I have with me Senior Advocate Pramod Duge, who again is a well-known and a name in the subject. He, in a sense, argues a lot of cases on this subject. And good to see you, Mr. Dube, today. I have with me Advocate Abhimanyu Bhandari. And in addition to arguing matters before the Supreme Court, one thing I like is that his pleasing style of argument. It is a pleasure to listen to you, Mr. Bhandari, and good to see you today on the show. I have with me today Neha Nagpal. She is managing partner of NN Law Chambers, who has, in a sense, briefed some of the biggest counsels on this subject, namely Senior Advocate Mukul Rohatgi. Also, if I'm not wrong, you were the ones who briefed in this matter. So I think you are, in a sense, the back force behind the push on this matter, in a sense, and lots of work at your end, I understand, because these are high stakes matters, and all the best to you for the case. And thanks so much for joining us.
Thank you.
May I request Senior Advocate Vikram Chaudhary, who, as I know, have argued hours in the court on this topic. Can you set the ground for today's discussion, and where are we headed from here?
Well, Tarun, at the outset, first let me say that your show is a platform, it's a showcase for a very eruditious and very insightful discourse always. And as I say always, that there's so much to learn. And when we share views across the platform, it is always a great learning experience. Since the matter is now sub judice, the issues that we are going to discuss here, so we'll discuss within those limitations as students of law as to what kind of views each one of us would have. Obviously, since we all represent one side of the spectrum, that is the accused side, and we would be more inclined to debate towards liberty, more tilted towards liberty than towards the invasion or deprivation of that. So keeping that conspectus in mind, we'll still, as I would say, students of law and in the court as officers of the court, we have to maintain that delicate balance. So when we talk about twin conditions, so there are myriad subjects which are before the Supreme Court now on various aspects. The PMLA has been, ever since its enactment and its coming into force, has been a work in progress. It is still at an evolutionary stage because we are dealing with some kind of, there are total about 115 amendments, and the last 3 or 4 years has seen approximately 2 dozen or more amendments. And all these amendments have far-reaching repercussions. So once an act needs to be amended so many times, it remains, as I say, work in progress and work in evolution. So if it is at the evolutionary stage, and therefore the Supreme Court is dealing with it, so there are many aspects which are thrown in. Few of them are very salient. One is the very commencement of investigations as to how a procedure is to be adopted. Is there a procedure contemplated therein, or the parent enactment of CRPC would come in? Then there is an issue as to what will be the impact of certain amendments carried out to, say, for example, proceeds of crime, or to the offense of money laundering, or to the trials. In Section 44, both the trials have to go before the same court. That is the trial in a predicate offense and trial and the money laundering offense. What is the nature and sweep of proceeds of crime? Is it to be deciphered and determined by the predicate agency or by the enforcement directorate, which is the authorized agency for investigating offenses under PMLA? Now, having all these issues in the ring right now, one of the crucial issues which you raise is on bail right now, the liberty, Section 45, twin conditions. So I was part of Nikesh Tarachand Shah in 2017, that case, celebrated case in Supreme Court, in which the Supreme Court struck down Section 45(1) to a limited extent. It said that insofar as the twin conditions are imposed, we are striking it down. So that if we look at the section as it existed then, it had Section 45, subsection 1, then clause 1I and clause 2I. So clause 1I was an opportunity to be given to the public prosecutor for opposing the bail, and clause 2I was containing those twin conditions. So if we look at the Supreme Court judgment, and which said that twin conditions are struck down, so effectively Section 45(1) clause 2 is struck down. It no longer remains on the statute book. The law is that once a provision is declared as unconstitutional, it becomes non-est for all purposes. It is as if it never existed. So if it never existed, all these publishers have been publishing these journals where the Bare Acts.
Quite well taken. I think the takeaway from your introductory comment is that, in a sense, the twin conditions ceased to exist 5 years ago in 2017. So I will now take this to Senior Advocate Pramod Dubey for his introductory comment.
Thank you, Tarun. Tarun, it's rightly pointed out by Mr. Chaudhary, the matter is sub judice before the court. But so far as Section 45 is concerned, I have one point to make here. See, there is a provision for the arrest under Section 19 of the PMLA by the Enforcement Directorate. Tarun, there is a little bit difference, and we must understand there is a difference between arrest and the custody.
Okay.
One is the arrest by the investigating agency, and second is the custody. Custody would be given only by the competent court of law or any court of law upon the production of the accused. So if you see Section 19, the Section 19 gives the jurisdiction and the power to an officer of the Enforcement Directorate to arrest the person. However, Section 45 is giving the power to the court for the release the person on the bail. So if you see together 19 and 45, then the 19 will not applicable for the anticipatory bail. Because in anticipatory bail, there is no arrest, it is a pre-arrest stage. So 19 is not applicable. If the 19 is not applicable, then Section 45 will not be applicable for the anticipatory bail. This is the one aspect. The second aspect, which has been pointed out, Mr. Chaudhary, and this also been argued, that that is sub judice before the court. So far, the revival, there is a lot of discussion is going on regarding the revival of this Section 45. The amendment and the debate which took place in the Parliament, and the act was produced before the Parliament, there is not a single amendment or anything mentioned that they are reviving twin condition of Section 45. This is number one. Second, validation of the legislation. That is also not done in Section 45. So as on date, in terms of Nikesh Tarachand,
yes,
twin condition is declared unconstitutional. It is non-est. And recently, the full bench of Supreme Court, in another matter, headed by Justice N. Nageswara, has given the finding that when the act is declared unconstitutional, it is non-est. So when it is non-est, it cannot be revived. Now,
so the Bombay High Court judgment doesn't stand according to you. The Supreme Court.
I will not make the comment on the Bombay High Court because it is also go through the test, and the Supreme Court is still to test the validity of the Bombay High Court judgment. The prima facie, as a lawyer, I don't think the Bombay High Court judgment is a good law, but it is subject to the examination by the Supreme Court.
By the Supreme Court. Point well taken. We will wait for the Supreme Court judgment to know more on this. Now, Mr. Bhandari, you wrote a book not too long ago on the Prevention of Money Laundering Act, and your views were very radical. You said that you want to scrap this act and get a new one in place. So I can presume that you don't want the sections, but the whole act to be rewritten. So what would be your introductory comment on this issue?
My introductory comment, Tarun, would be that, I don't think so. This is the right forum today to go into the legal niceties of Section 45 and its validity. I think that is being thrashed out before the Supreme Court. And I think we all in the country are now going to await for the decision of the Supreme Court. However, I have a couple of points to make on the larger, broader picture. Okay. An interesting argument has been raised by Mr. Vikram Chaudhary, I think in court and also today, that 45, the twin conditions were in 45(1)(2). They went away. The amendment was really to 45(1). So there was not even an attempt to revive 41(5)(2) by the Parliament. It's a good argument that actually it was never revived back by the amendment. But the issue is that, we can say that today it will take them next session, an ordinance will come and bring the whole thing back. And we'll again be in court trying to justify or whether 45 should exist or doesn't exist in the statute book. All the amendments that have been made to the PMLA in the recent time have been initially been made by way of an ordinance. None of those amendments were thrashed out before a select committee. I don't know if you're aware, but before the PMLA Act came in 2005 and 1999, when it was a bill, there was a select committee which went through provision by provision and made certain very harsh comments. The bill was then amended and then the act came. So certain provisions were put in, certain checks and balances were put in. The amendments which have come from 2014 onwards have come in without going through the motions of any select committee. So therefore, it's a bill which no select committee has really thought of or gone through and given their comments, like we had seen in 1999, like we had seen in 2011 also when certain amendments were made. But coming back to the twin conditions, my specific point is that, we have gone now, a lot of water is flown through. I don't know if you're aware, but I think one of the tallest leaders post-independence, Mr. Arun Jaitley, once in the parliament in 2012, when they were bringing the twin conditions in the Customs Act, had said that, those years have gone. Now we have to think forward. Bail is a right, and therefore you can't have such provisions anymore. And thankfully, the government at that time did not insert the twin conditions or something similar to the twin conditions in the Customs Act. So, we have gone through, our country has now lived through draconian bail conditions. And therefore, I think the time has come when we should remove these twin conditions from every statute book. And I see no reasons why it should be in the PMLA. I see no reason why it should be in the Companies Act. There's a similar twin condition which is in the Companies Act. I just don't see why it should be there in the Companies Act. We already have a considerable body of law. It's not like anybody automatically gets bail. One has to justify. There is a full test which the Supreme Court has laid down in various judgments, which one has to satisfy before getting bail. Those themselves take care to ensure that in grievous offenses, one is not let out if that person will again commit an offense or will run away from court and not face trial. So I don't see that how there is a justification to have a twin condition in today's times. Also, Tarun, PMLA is not a creature of our own thinking. PMLA has been pushed, shoved and stuffed on us pursuant to the Vienna and the Palmero conventions. None of those, and I'm telling you, none of those countries are also, other countries also who've adopted similar acts like PMLA. There has been a lot of debate in those countries also that it has a disproportionate impact on innocent people. It's not only in our country. And I tell you that the Palmero Convention and the Vienna Convention, none of them say that there should be a twin condition to deny bail. None of those conventions.
So this is India-specific law, basically.
The UK PMLA Act also doesn't impose twin conditions. So I am not understanding why do we need these twin conditions in today's day and age. Every time we've seen it try to come out. I mean, thankfully, in the Customs Act, we didn't get it in 2012. And you know why it was being brought in 2012 in the first place in the Customs Act? Because Supreme Court a year before that had said that custom offenses, you're entitled to bail because they were non-cognizable.
Thanks for this comprehensive introductory comment on this issue. I will go to Neha Nagpal from NM Law Chambers. Neha, two questions to you, very specific. Whenever they are accused clients that you deal with in money laundering cases, how difficult it gets to explain to them that they are not getting bail because the court has to be satisfied on the date of the first hearing when they are being presented for bail that they are innocent. Because the law as it stands is you're innocent until proven guilty.
Correct.
And what kind of chilling impact it has on businessmen that you know that the law has been turned upon its head in this matter.
Correct.
And what is then the investment? Tell me, when you're dealing with somebody who's sitting on 2,000, 3,000 crores of investment, I mean, it takes a big heart to put money. If somebody is taking so much of money and putting into our country, do you think such businessmen at least deserve a little respect in terms of when laws are designed? So do you think that is why the 2017 judgment of Nikesh Tarachand was landmark? And can you develop on what I just said and also give me your opinion?
So, Tarun, I think the queries you raised are very pertinent. It's almost like you have had the experience of dealing with clients who are going through a situation like this. And in literally one sentence, clients facing, the RBI circular on fraud, the minute you're declared fraud, CBI registers an FIR, and pretty much sometimes within days, on the same day or within a month, you have an ECIR which gets registered. And it is nightmarish for a lot of entrepreneurs, for a lot of industrialists and businessmen who have to face suddenly, two agencies together for the same set of allegations. Now you are, and when I'm saying same set of allegations very cognizantly, because literally in most cases, the ECIR is a replication of the FIR. And so many times for the predicate offense, which is the CBI offense, the IPC offense, they're not arrested, but they get arrested the minute the ECIR is registered. How do you explain that to them? That first, let's at least establish I've done something wrong. Second, you have to meet with these harsh conditions to prove you've done nothing wrong. Many a times when ED arrests, charge sheet, CBI has not gone forward. So, it is a conundrum. It's absolutely, it's tough for lawyers as well. It's definitely tough for the entrepreneurs, and it does at some level dampen their spirit. Yes. We have built infrastructure, we have paid our taxes, we have created economic growth, contributed to it, we have created employment, and is this what?
And the good point is that if we in a sense do away with such draconian laws, at least the thought that let's put our money abroad instead of India will vanish away, because they will have renewed confidence in the country.
But Tarun, we have to strike a balance. You can't have no law at all, because then you're in a state of complete lawlessness. But you can't even go so after somebody where you kill the spirit of entrepreneur.
4 issues. Have you ever seen in your life that on the same day the FIR and the ECIR gets registered back to back? Secondly, the issue of attachment. Thirdly, the issue that we see is that long incarceration and the resultant impact. Could you share all this with us?
Tarun, I think Neha has pithily and very aptly put that money laundering has a very laudable objective to achieve.
Yes.
It is our country's commitment to international political declarations and all those conventions. So it has to be in place. The only problem now is its indiscriminate application and its non-adherence to what we call in India Article 21, procedure established by law. So that procedure has to be well defined. It has to be transparent. It cannot be opaque. It cannot be within the discretion or arbitrary whims or fancies of an officer. It has to meet the test of, transparency and objectivity. Coming to your question straight away, whether FIR and ECIR on the same day. Now, we are witnessing those cases where actually there is no FIR in existence. Assuming that a request comes from a foreign country that an offense is committed in that country, and therefore there is a reciprocal arrangement contemplated under PMLA. and there is a request for freezing or attachment of property. So the Enforcement Directorate, considering that those offences in that country are equivalent to offences, so-and-so offences in India, and they find place in the schedule to the PMLA, they have gone on and registered ECIRs without even there being an FIR. So I have also seen cases where the Enforcement Directorate itself is the complainant in the FIR. They go and lodge an FIR, and then on the same day, they lodge an ECIR just to take over the investigations. I have seen those cases where in the scheduled offense, the CBI has concluded we are closing the case. We have not found any evidence, but the Enforcement Directorate says, sorry, we have found evidence. We will continue with it. So therefore, I said that all these rough edges have to be smoothed.
Good point, and I will take this point to Senior Advocate Pramod Dubey. So if you could tell me in the predicate offense, which for common viewers is the first offense, which is in a sense, the FIR is filed, say, by the Delhi police. If I get acquitted in that, then can the PMLA case go on?
Tarun, you have put a very good question. I have the experience recently in one matter I was doing.
Is it?
Where there was an allegation against my client, being the public servant, he took the bribe from a private person to do some act. The trial concluded, and the court has given the clear finding that there is no evidence to even suggest remotely that any bribe was given by the private person to the public servant. Bribe is the proceed of crime. There is a finding there is no proceed of crime. Despite this finding, an acquittal under Section 7 of the Prevention of Corruption Act, the proceeding in prevention of money laundering is going on. You know, PMLA is altogether different. It cannot be, if you see Section 3, in Section 3, the main ingredient is the proceed of crime. And the proceed of crime is defined under Section 2U. 2U related to the schedule offense, that is the predicate offense.
Yes.
If there is no schedule offense, no predicate offense, there is no question of the proceed of crime. If there is no proceed of crime, where is the question of the continuation of the trial under PMLA?
A very well made out point. Now I have two questions for Advocate Abhimanyu Bhandari. Have you ever seen a situation where, and if you could share with our viewers, that somebody has in a sense made out money from a corruption or a corrupt activity? But that's point number one. Point number two being, he has not laundered it to create any asset. So he has money in his bank account, he has in his cupboard, maybe in his cupboard or wherever he's put it, in some flat or wherever, in farmhouse, whatever. But he's not created any asset. Does it amount to a case of money laundering, or are people booked for such cases? Or it would only be a case of corruption and not money laundering?
Well, that's a very, very interesting point, Tarun. And I think this is something which I think is being hotly debated in various courts all over the country now as to what constitutes money laundering.
Yes.
I have been saying this from the very beginning, and I have spent a considerable amount of time in my book where I've said that this is not a Proceeds of Crime Act. This is a Money Laundering Act.
Yes.
So really, if you have proceeds of crime with you, that in itself, the use or the possession of proceeds of crime is not money laundering. Money laundering is when you're actually trying to launder that money.
Yes.
So, you know, if someone X goes and steals gold from someone else and keeps that gold under his bed, that's not money laundering. Money laundering is when he converts that gold into currency, and that currency is then deposited in his friend's account, who he says, show it as your regular income and buy a property for me, which I will use for my benefit. Then that becomes a laundering. And therefore, on this, there is considerable amount of law in the US where, you know, people who've got proceeds of crime, who have then gone and bought a car for them or bought a house for them, courts have said, sorry, that's not money laundering, and that's not concealing money. Concealment only comes when you try and really do something grave to hide its illicit origin. That's what money laundering is. And I think this is one of the aspects that we are, that's being argued in the court. And soon I'm sure we're going to get clarity as to what is money laundering and what is not money laundering.
So very interesting.
Very, very important point.
So the conundrum is very interesting. that there is confusion on the concept of money laundering even now in this country. What is laundered money is not clear, and people are being convicted. People are spending years in jail. And that is a tragedy of epic proportions that we are facing today. Of course, the courts will adjudicate. I think there'll be light at the end of the tunnel. Closing comment for you, Neha Nagpal.
My own humble view is that I definitely do think that, coming back to the twin conditions, they are harsh, they're excessive, and they are definitely killing the spirit of entrepreneurship. I definitely also do believe that we need to strike a balance between a law that is functional, workable, attacks its cause, as Abhimanyu correctly put, money laundering, not simply proceeds of crime. That is dealt with under the IPC. Money laundering specifically should be the objective, and that should be tackled with under the PMLA Act. And lastly, I think, as the point has been made by both Mr. Chaudhary and Mr. Dubey, that one, you cannot have ED at a case, at a situation where without a predicate offense, they are registering ECIRs and launching investigations, because that is literally going to weaken our economic growth pattern. And that's exactly the submission which Mr. Kapil Sibal has made before the Honorable Supreme Court in the present batch of petitions that's being argued. So I think it's key to sort of reevaluate the law, and I'm sure the Supreme Court is going to do that aptly and correctly in due course.
Very interesting points out of today's show. That is it a Proceeds of Crime Act or is it the Money Laundering Act? That has to be clear first. On that note, I would like to thank Senior Advocate Vikram Chaudhary, Senior Advocate Pramod Dubey, Advocate Abhimanyu Bhandari. Mr. Dubey, you have to point to make. You have 30 seconds. No. Advocate Abhimanyu Bhandari, Neha Nagpal from NM Law Chambers. Thank you for sharing that comprehensive perspective with us. We for sure will get to do a show after the judgment comes out. Either ways. And of course, we had a differing opinion. We have Abhimanyu Bhandari, who completely wants law to be scrapped. And there are others who are arguing on other Section 3 and Section 5.
Let's end it on Shakespeare's famous quote: "In the pursuit of justice, let none of us seek salvation."
Thank you so much for sharing that, Mr. Chaudhary. Thank you. Thank you so much for sharing.
Thank you.
Thanks.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.